emergency, and to now include expediency reflects our commitment to improving the Assembly's operational efficiency and effectiveness. By modernizing how we meet and deliberate, we strengthen democratic practice and expand access to parliamentary business. I trust today will be a constructive learning experience for all, and as we go along, we will certainly improve. I also place on record our sincere gratitude to Sri Birla, the Honorable Speaker of the Lok Sabha, the Parliament of India, and the chairperson of the 28th Conference of Speakers and Presiding Officers of the Commonwealth, and to the people and government of India for their warm hospitality during the conference held in New Delhi from the 14th to the 16th January. Belize was ably represented by the Deputy Speaker of the House of Representatives, the Honorable Marconi Neal, by the President of the Senate, accompanied by the Clerk of the National Assembly, Ms. Clarita Petch. The conference discussions on AI in Parliament concerned balancing innovation, oversight, and adaptation, the impact of social media on parliamentarians looking at security, health, and wellness, and strategies to deepen public understanding of Parliament and citizen engagement beyond voting. These are all directly relevant to our work. The strengthening of parliamentary networks and knowledge constructed during the conference will inform ongoing deliberations in the National Assembly as we pursue a more open, inclusive, and responsive Parliament. Finally, I take delight in noting the unprecedented number of requests for leave to move on the adjournment of the Senate for the purpose of discussing a definite matter of urgent public importance. We had 3 in total, these that were submitted to the President. Perhaps the inspiration is rooted in the fact that we are meeting virtually today. These requests were submitted in accordance with Standing Order 12.2 and is certainly a step towards strengthening our democracy and the value of the Senate's oversight and scrutiny role. However, subsection 4 of the said standing order states that not more than 1 motion for the adjournment of the Senate under this standing order may be allowed at one sitting. The approach was, having been satisfied of the 4 criteria for allowing the claim were met, a decision was made based on a first-come, first-served basis. For transparency, the records show that 3 submissions were received, one at 3:38 p.m., one at 4:36 p.m., and the final at 8:40, respectively, on January 22nd, 2026. Consequently, the leave was granted for the submission clocked at 3:38. However, there has been a withdrawal of that submission, and the submission that was second in the queue at 4:36 p.m. has been allowed. I am also using this opportunity to share that I am revisiting the interpretation and practice of dealing with submissions under this standing order, considering the great interest in it, and will be issuing a practice notice for future reference. For today, the approach will be that the motion for the request for leave for the Senate is, once it is given, will be placed for the hour of the adjournment. As a reminder for today's virtual meeting, first, the operational protocol calls for the use of raise hand icon. You can also raise your hand physically if you so choose, as we often intend to do that automatically. Secondly, when making an intervention, you don't need to rise, you may sit. Having said all that, I now move to the presentation of reports from Select Committee. I recognize the Honorable Vice President on behalf of the Chairperson of the Standing Committee. Honorable Vice President.
Thank you, Madam President. Madam President, I rise to lay on the table sessional paper number 28/1/15, report from the Standing Orders Committee on the operational protocols for virtual sittings of the Senate.
Honorable members, that report is ordered to lie on the table.
Motions relating to the business or sittings of the Senate.
I recognize the Leader of Government Business.
Madam President, I move that at its rising today, the Senate adjourn to a date to be fixed by the President.
Honorable members, the question is that at its rising today, the Senate adjourn to a date to be fixed by the President. All those in favor kindly say aye. All those in favor kindly say aye. You may unmute your
Aye.
mic or raise your
Aye.
hand. Those against kindly say no. The ayes have it.
Public business, government business. Bills for second reading.
Madam President,
I
I
recognize
move
the
the
Leader
second
of
reading of a
Government
bill for an
Business.
act to repeal and replace the Legislative Assembly Powers and Privileges Act to declare and define certain powers, privileges, and immunities of the National Assembly and of the members and officers of such assembly, to secure freedom of speech in the National Assembly, to regulate the admittance to the precincts of the National Assembly, to give protection to the persons employed in the publication of the reports and other papers of the National Assembly, to provide for matters connected therewith or incidental thereto. Madam President, very briefly, senators, I believe, will appreciate that we are today debating a bill that seeks to repeal the Legislative Assembly's Powers and Privileges Act. In fact, it's an ordinance. It was actually enacted in October 1962. That is, before self-government and at a time when only the Legislative Assembly existed. There was no Senate. Looking at the history of that ordinance, it has never been amended. In short, it does not suit the reality of our Parliament today. And therefore, after much work, the bill that is before us has been brought to the National Assembly in order to modernize the legislative framework that governs our work, that governs work of the Senate, the House of Representatives, committees of both houses, and joint committees. Most important, it continues to ensure that there is freedom of speech in the Houses of Parliament and committees, and it permits senators, and I speak for this House, senators to speak frankly, openly on public matters that are before the Senate meetings or before committees, and to be protected from exposure for defamation if someone feels aggrieved by what is said. Madam President and colleagues, that privilege which is being granted to us also imposes a duty on us to exercise moderation, discretion, and to ensure that we do not unfairly target persons simply because we are privileged to speak without recourse. So, whilst we enjoy the freedom of speech in the National Assembly, which we should exercise to the fullest, we should do so responsibly. The second point I wish to raise is the fact that committees of the Senate in particular have had difficulties in bringing witnesses and securing documents to bring them before committees of the Senate. What this bill proposes is a new regime that strengthens and gives power to committees to make requests or issue summonses to witnesses for documents to be brought, and to have, one, some immunities, but more importantly, a very clear regime to address persons who are required to appear, who are required to answer questions, and people who are required to produce documents. Where the Senate committee believes that that is not being done, not being respected, there are remedies and enforcement measures in the legislation. In short, I think we will all agree that the bill modernizes our procedures. It makes our work more transparent, and it also makes our work more effective. I therefore commend the bill to colleagues. Thank you, Madam President.
I recognize Senator Patrick Farber.
Madam President, I rise to speak to the National Assembly Powers, Privileges and Immunities Bill, and I thank the lead Senator of Government Business for his intervention. And I want to say from the onset that I, along with the members of the opposition, embrace the need for the updating of this very important piece of legislation. The leader is right that it has been long overdue, and it is time that we progress. But Madam President, it is important that there is a clear understanding of the importance of the privileges in this democratic system. Privileges exist to protect the independence of the parliament and to secure the freedom of speech within these chambers and to ensure that legislators can carry out their constitutional responsibilities without fear or undue interference. It was never intended to insulate the executive from scrutiny or to frustrate the investigative role of Parliament in this piece of legislation. And at first glance, Madam President, the bill presents itself as a kind of modern reinstatement of long-standing principles. However, when you look at the bill a little closer and you examine it, it raises serious concerns about balance and about accountability and the effective functioning of parliamentary oversight. The bill expands powers to summon witnesses, as the leader of Government Business just said, and also to summon documents, but it is simultaneously introducing provisions that significantly weaken the very powers that it purports to improve. Our gravest concerns, Madam President, lie in section 16, subsection 2. That provision states that no public officer shall be required to give evidence or produce documents relating to unpublished official records or affairs of the state, except with the consent of the Governor General. Madam President, on its face, this may appear to be a procedural safeguard, but in reality, it introduces a fundamental obstruction, in our view, to the parliamentary inquiry process. The Governor General acts on the advice of the executive, and we should not forget that. Therefore, this section effectively places the executive in a position to control who may appear before parliamentary committees and what evidence may be disclosed. This creates a situation where Parliament can summon witnesses in theory, but be blocked in practice whenever scrutiny becomes uncomfortable or practically inconvenient or politically inconvenient. This provision, Madam President, frustrates the parliamentary process in a very real and practical way. Committees of this National Assembly are tasked with examining public administration, public expenditure, and matters of national importance. Our work depends on timely and unfettered access to evidence from public officers. By requiring consent before participation, section 16, subsection 2 introduces delay. It introduces, Madam President, uncertainty, and it is a clear risk, in our view, for political interference. Even more troubling, Madam President, is the breadth of the language used in the proposed legislation. References to unpublished records or affairs of the state are narrowly defined. A public officer need only assert that information falls within those categories, to trigger the consent requirement. And this creates an incentive for overclassification and silence rather than cooperation and transparency. The result, Madam President, in our view, is a serious imbalance. Earlier sections of the bill empower the chambers to summon witnesses, as you heard the leader of government business say, to compel attendance, and even to issue warrants in cases of refusal. But subsection 16(2) then quietly neutralizes those powers by inserting an executive gatekeeper at the point where accountability should be the strongest. The Senate, in particular, has a constitutional role, not a regular role, as a reviewing and accountability body. This provision weakens that role. It shifts the balance away from the legislative oversight and toward executive control. It undermines confidence that Parliament can independently examine the actions of those who govern. Parliamentary privilege, Madam President, properly understood, should enhance transparency while respecting narrowly tailored exceptions for genuine national security concerns, and we can appreciate the need for that very much. But what this bill does, Madam President, instead is reverse that principle by making disclosure the exception and executive consent the rule. This bill is to serve democracy rather than diminish it. Section 16, subsection 2 must then, Madam President, be reconsidered. At a minimum, its scope should be limited to clearly define national security matters. Refusals should require written justification, and there should be a mechanism for parliamentary or judicial review of such refusals. Parliament must not be asked to voluntarily surrender its own oversight authority. Madam President, the Senate should be cautious of any legislation that weakens its ability to hold power to account. As currently drafted, Section 16(2) frustrates the very purpose of parliamentary privilege. It requires amendment if this bill is to truly protect the integrity, the independence, and the effectiveness of the National Assembly. So while, Madam Speaker, generally we support its introduction as a way of making anew the protection for speech of our senators and our public servants to some extent, we cannot on the opposition side support this bill in its current form unless we can see some amendment to section 16(2). Thank you, Madam President.
Senate I am not seeing a hand raised. Will someone be additionally speaking on the bill?
I have my hand raised, Madam President.
It's a learning experience, Senator Herrera. We are getting used to this. And I recognize Senator Kevin Herrera.
Thank you, Madam President. Good morning, colleagues. I rise today to speak on the National Assembly Powers, Privileges, and Immunities Bill 2025. Madam President, like the leader of the opposition business mentioned just now, there are some good aspects to the bill, but for reasons that I will be getting into in my presentation, I will not be able to support this bill in its current form. Madam President, on paper, this bill purports to define our powers, but if you look closely, if you truly scrutinize it, we see that it actually does the opposite. It dilutes, frustrates, and ultimately neuters the constitutional mandate of this upper house in providing oversight to the executive branch of government. We all know, Madam President, that under Section 61A2D of the Belize Constitution is the bedrock of our authority. It empowers the Senate to inquire into any matter of public interest or concern. That is our charge. That underlines our power, Madam President, to be a watchdog, to investigate corruption, to demand accountability from the executive. But to do that job, to investigate, we cannot be legislatively and procedurally handicapped. We need speed and we need the ability to compel compliance. We saw that in the last Senate hearing that we had, Madam President, where it became very difficult for the committee to carry out its mandate, given the constraints we had. This bill, Madam President, gives us none of those things. Instead, it introduces bottlenecks, weak penalties, and loopholes that leave us toothless in the face of a recalcitrant executive. Let me take you through the specific weaknesses that make this legislation dangerous to our democracy. The affairs of the state loophole, Madam President, I think is the most serious of them. This is perhaps the most debilitating clause in the entire bill. Clause 16.2 states that no public officer can be compelled to produce documents if they claim the matter relates to affairs of the state, unless the Governor General consents. Now we know the reality of our system, Madam President. The Governor General typically acts on the advice of the Prime Minister or the Cabinet. So let us play this out. If the Senate is investigating executive corruption or mismanagement, the Governor General reaches out to the executive. The executive can simply advise the Governor General to withhold consent under the guise of affairs of the state. It's a very broad term. Anything can come under that term, Madam President. It's like in football. I don't know if we watch American football, Madam President, but you know there's this desperation play at the end of games when teams are behind that they call a Hail Mary. It reminds me very much of that, Madam President. It's pretty much done in desperation to catch whatever was missed during that time. The result is absurd, Madam President. This very entity we are investigating holds the key to the evidence we need to investigate them. It is a fox guarding the henhouse that is codified into law. This clause states that we cannot prosecute anyone for lying to us, and I'm talking about clause 38 now, Madam President. Clause 38 says that we cannot prosecute anyone for lying to us or obstructing us without the report going to the Attorney General and receiving the consent of the Director of Public Prosecutions. The Attorney General is a member of the executive, Madam President, similar to what I went over a little earlier. And are we expected to believe that the Attorney General will eagerly facilitate their prosecution? This creates an inherent conflict of interest, I believe. It gives the executive a veto over our enforcement powers. And then if we look a little farther on the clause 14, Madam President, I believe Parliament should have the power to address contempt immediately. This bill outsources that power to the judiciary under clause 14.1. If a witness refuses to answer, the President may refer the matter to the High Court. Note the word may, Madam President. It is discretionary. If a future president, and I'm not speaking about yourself, but if a future president is partial to the government or to a witness, they can simply refuse to make that referral. This again handicaps the committee to further investigate and to move the process forward. Furthermore, we know the pace of litigation. Senate inquiries are time sensitive. We saw that in the last Senate investigation we did, Madam President. By forcing us to pause proceedings and file a reference with the High Court, we are inviting massive delays. A hostile witness can simply sit back and refuse to answer, and knowing the legal process will take months or possibly even years. By the time a ruling comes down, the political momentum is dead, but even more so, the session of parliament may have come to an end, and thereby kill our report, like what we saw um, in the last Senate investigation we did. Madam President, and Madam President, for this, we're not even talking about the cost of that yet. Remember that the Parliament does not have its own attorney. This is something that I think we've spoken about in the chamber, but we don't have that, and so when an investigation takes place, the chair of that committee needs to send a budget up to the Ministry of Finance, which is then looked over. And you'll recall in the last investigation we did, our budget was slashed in half for no reason other than budgetary purposes, without really looking at the merits or demerits of the line items. Madam President, again, taking us through that whole court system really puts future investigative committees at a major disadvantage, and it's certainly something that I think causes significant concerns and prevents us from supporting this bill. Now, under clause 22, Madam President, if a witness refuses to show up to the Senate, the maximum fine is $750. Again, that's a paltry sum, Madam President, given the gravity of some of these issues that would likely be investigated in the future. Madam President, if we're investigating a multi-million-dollar scandal, a scandal involving theft of public funds, do we honestly think that $750 fine will act as a deterrent? Of course not. For a corrupt actor, that is not a penalty. That is petty cash expense, and it is a cost of doing business. It turns non-compliance into triviality rather than serious offense against the Constitution. Madam President, regarding warrants, again, this is something that we dealt with quite significantly in our last investigation. These clauses grant witnesses the same broad privileges that they would have in a civil trial. While we respect the legal privilege, Madam President, a parliamentary inquiry into public funds should, I believe, be different. This broad definition invites witnesses to hide behind excessive legal technicalities, bogging us down in arguments about privilege rather than getting to the facts, bogging us down with high legal costs, and further bogging us down when we have strict time limits to complete the process. In conclusion, Madam President, this bill appears to provide some structure, but in practice, it places the executive and the judiciary as barriers between the Senate and the truth. By stripping us of direct punitive powers and allowing the executive to withhold evidence under the label of affairs of the state, this bill effectively neutralizes Section 61A(2)(d) of the Constitution. And I believe, Madam President, given clearly what the Constitution states in 61A(2)(d), I believe that this clause may actually be unconstitutional. It turns the Senate from a constitutional watchdog into a bureaucratic committee that can request answers but can never demand them. We cannot accept a bill that renders us toothless, Madam President, and so I urge my colleague, while we're not strictly doing this to oppose the current administration, but I think that we want to make sure that future committees that are investigating any type of issues of public interest, Madam President, can carry out that function. And I really don't believe that it will be able to happen under the current bill for reasons I just stated, Madam President. Thank you.
Thank you, Senator Herrera. I see Senator Chanona. Senator Chanona, you have the floor.
Good morning, Madam President. Good morning, colleagues. Madam President, at the outset, let me state that I too have a constitutional concern to aspects of this bill. I don't think it's lost on any of us that it is indeed historic that we're looking at a legislation 64 years old. Some of us may be a little older than that, but I digress. But I do take the point as being informed by my experience as chair of the last Senate Select Inquiry, that notwithstanding its age, this was still deemed good law by the court, High Court of Belize. And notwithstanding that, Madam President, that it was still, there were still attempts to leverage age as some type of issue and to say that it was not applicable. But as we know, we must respect our elders. So notwithstanding that, I will support updating the Powers and Privileges Bill. The 1962 date means that it predated the Constitution. So like Senator Herrera and Leader of Opposition have called out, we need to make sure that it aligns with the Constitution. As part of my research, Madam President and colleagues, I looked to different pieces of legislation in other Commonwealth parliaments, particularly Jamaica and Trinidad and Tobago. And I found this exact section referring now to 16.2 in Jamaica's Powers and Privileges legislation, but they did not include affairs of the state. Their phrase is public service. And Trinidad's version of this protection for its parliamentarians is much shorter. I think it's only like 2 or 3 pages, looking broadly and comparing it to the Constitution, of making sure, exactly as Senator Herrera called out, that aligns with the constitutional powers in saying anybody can come, anybody that's deemed relevant can come by his office. So it relates to public business and public interests in affairs of the state. So I remain unclear, Madam President, as to the rationale for including this, because it seems like we, the drafters, included this deliberately. And I have to say, by this time, it would be public record that I appeared in my other capacity in the lower house when this bill was presented and made a number of interventions and suggestions for change. And this was one of them. We also had a working session in 2025 on this, and similar concerns would have been raised. So no one should be surprised that this concern stands, given that we're still seeing this type of I would say, very broad statement. And I'm interpreting as read. State of affairs is not listed in the interpretation at the beginning of the bill. So we can't see that this is limited to affairs of the state regarding security concerns or regarding any other category. Affairs of the state, to me, is what we do here, Madam President, what we are have sworn an oath to do. So because of that fear of supporting something that to me reads as unconstitutional, I also took it upon myself to confer with other speakers of Commonwealth parliaments that I've had the opportunity to meet and asking their insight. And they were also at a loss as to what the rationale would be and how that supports what our Constitution conveys, both in terms of separation of powers for the different parts of our democracy, but also for the specific, as Senator Herrera has called out, specifically for the powers and functions that the Constitution gives. And I do take note that it has been represented to me that any law that contravenes the Constitution falls to the wayside and, you know, doesn't apply, isn't legal. As Senator Herrera called out, we saw where those types of legal challenges took time away and muddies the water. So I do think it's important that we make every effort to ventilate these concerns, make adjustments where necessary before we advance with this legislation. So at this time, with this current version, I am not able to support this draft, Madam President. Thank you.
Thank you, Senator Chanona. I recognize Senator Louis Wade.
Thank you very much, Madam President. I'm going to be brief because I want to start by saying that I support my colleagues in what they have been saying so far as it relates to this bill. I too was a part of the working session that was held in Belize City, and I brought up point 15, and I noticed there has been some change, but not to the extent, and it still does not solve the problem that I had stated. Number 15 says every person summoned to appear before either chamber, a committee, or a joint committee in accordance with Section 9 may be represented by an attorney at law, provided that the attorney at law is not a member or officer of either chamber. The wording of this particular legislation is present tense. It says, provided that the attorney at law is not a member or officer of either chamber. The example that I brought up had to do with a former member of the executive who clearly was at one time sitting in the chamber. That executive member is no longer in office, but is still an attorney at law. And in a previous Senate Select Committee investigation, that former executive, who is currently an attorney, appeared as the attorney for an individual who was summoned before the Senate Select Committee. And in my opinion, the questions that were being raised were related to the term of office that that particular attorney at law, who is now representing the person being questioned, was representing that individual. I believe it should never have happened, and I believe it should never again happen. And the way this legislation is written, it is only if that attorney at law is currently in the chamber that he wouldn't be able to make representation on behalf of a person. I had brought it up, and as I said, I believe without mentioning names per se, that it also refers, it should refer to a former member of the chamber if at least that particular former member was involved directly or indirectly with the matter that is being investigated. So that relates to 15. And then I also take issue with 16.2. And I believe that all Belizeans should pay very close attention to what is being argued, why section 16.2 is being flagged by my colleagues, where it states no public officer, except with the consent of the Governor General, shall be required to produce before either chamber or committee any paper, book, record, or any other document, or to give before either chamber or a committee any evidence on that matter. And so I do agree and believe that it beholdens the Senate to the Governor General as it relates to what can and can be said by a public officer when certain questions are asked. And based upon my observation, the Governor General does not have a full cadre of professionals that can help him or her make that determination. And that Governor General then must depend upon the existing public service, be it the Attorney General or others, that may be a part of the investigation itself. And so I am not satisfied the way it is currently written, that the Senate in this particular matter, like those who the Senate would like to call to make representation or to make a presentation before the Senate, must first gain the approval of the Governor General. I have, since my short time being a senator, listened to multiple of my fellow senators complain about what happened in the last Senate Select Committee investigation. When does the Senate approve an investigation? It is when the people of Belize demand answers, and those answers are not forthcoming. So, and I dare say I believe that we are either there or heading there again. And so we need to ensure that the legislation is written in such a way that Belizeans are able to get the answers that they are asking. And section 16.2, in my opinion, seeks to place very heavy fetters on the Belizean person's desire to get to the truth of a matter. And so what happened in some of these previous Senate Select Committee investigations must not happen again. If we are going to do justice to the people of Belize, to ensure that the Senate is able to carry out its responsibility to get to the bottom of matters, then section 16.2 needs to be clarified. I believe it needs to be clarified too in that statement that says affairs of the state. I mean, the Senate is also responsible to ratify treaties. I believe that we are privy already to sensitive information. And if we are going to get to the bottom of certain matters that provoke the Belizean psyche, then there needs to be a clearly defined inclusion of what we mean by affairs of the state, so that it is not used as another opportunity to frustrate the Belizean public in trying to get to the bottom of a matter. And so the way this particular bill is stated, I am not prepared to support it until we are able to get clarity on these matters. Thank you, Madam President.
Thank you, Senator Wade. I recognize Senator Hector Guerra.
Thank you, Madam President. And Happy New Year to all my colleagues here today. I've listened keenly, Madam President, to the concerns being raised, and I want to make a contribution in terms of the thinking I think that would have gone behind the legislation. And I want to start with Section 16 because it has raised a number of concerns. I think if we take a step back, Section 16 is addressing what we understand in law to be called crown privilege. So there are a number of privileges that exist in law, one of which is called crown privilege. It means that matters that affect national interests, matters that may affect the proper governance of a country, are given certain deference by the legislator, by the legislative branch of government and by courts, because naturally, if a matter is unpublished, one wouldn't want that to be released in the context of a public hearing where it would be detrimental to the national interest of a country. For example, there may be ongoing negotiations between two states that may be pertinent to an ongoing public hearing, but because it hasn't been concluded, it may be detrimental to release that information. So I want to start with that, framing it by understanding what Section 16 is trying to protect. It's trying to guard the state against the revelation of evidence that might affect proper governance. That's number one. On the issue of why it is that the Governor General has to approve this, and it's circumscribed. If one looks at Section 16, it says the Governor General has to consent to these books, papers, etc., that relate to matters of records of any naval, military, or air force or civil department, or to relate to any affairs of the state. The Governor General needs to approve this in law because privilege, Madam President and members, privilege can only be waived by the beneficiaries of the privilege. So when the Governor General consents to it in these circumscribed matters, it's because the Governor General is speaking on behalf of the state and it's saying, fine, we can release this very important information that may affect the governance of the state. So that is why the provision is saying that the Governor General has to consent to the release of that information. The third matter that has been raised with Section 16 has to do with the term of art called affairs of the state. I hear Senator Chanona and I hear Senator Herrera, and I believe Senator Farber raised it. The legislation could have provided the definition, but that by itself does not mean that it isn't a term of art in law. Madam President, with your permission, I'd like to read from a decision that considers what affairs of state means. It's a term of art in law. It has a certain definition. And I'd like to read from a decision from an Indian case which I quickly found. It's the state of Punjab versus Sukhdev, and it's a 1960 decision. And it's interesting because the provision that we're looking at today, in fact, emanates from what is the English Evidence Act, which found itself in the various colonies. So it would have found its way into Jamaica, into Trinidad, etc. But it says, what are the affairs of state under section 123? Affairs of state would have meant matters of political or administrative character relating, for instance, to national defense, public peace and security, and good neighborly relations. Thus, if the contents of the documents were such that their disclosure would affect either, and I underscore, the national defense or public security or good neighborly relations, they could claim the character of a document relating to affairs of the state. There may be another class of documents which could claim the said privilege, not by reason of their contents as such, but by reason of the fact that if the said documents were disclosed, they would materially affect the freedom and candor of expression of opinion in the determination and execution of public policies. So the point that I'm trying to bring across is, while I hear the concerns, I'm sure the drafters behind the piece of legislation have no malintention. It is simply that in this sphere of legislation that exists, there are certain terms of art that are common. There are certain things that exist, and the provenance of this is simple. It is crown immunity, one. It is the state that would have to waive that, which is why the Governor General has to consent to the revelation of the information. And importantly, three, the reason the provision exists is because it is attempting to protect the state against the disclosure of information that would affect proper governance, Madam President. The last point I want to raise in terms of this section 16.2 is that it is not for the presiding officer or the chairperson to decide ultimately whether the information will be allowed or not. There is an ultimate backstop which is placed within the legislation, and that's found at section 14. What section 14 envisions is that when a witness raises an immunity and says, well, hold up, I won't release this information, the legislative drafter has, in their wisdom, said, wait, we need to balance the interest of the public hearing that is ongoing against the interest of the witness. And if we need to balance that, then it can't be a decision for any of the parties involved in the ongoing hearing to decide whether that information will be released. So what it does is it escalates it to a third independent party, which is the judiciary. So the ultimate backstop is for a court to then decide whether in fact the crown immunity, which I just alluded to, exists, Madam President. And it's key to look at this section 14, because what it does is at subsection 3 of section 14, what it does is it puts the obligation on the witness to justify through an affidavit why it is that the information should not be disclosed. And if that reason is not sufficient, if that witness is not able to show properly that it would affect proper governance, then a court will decide that it needs to be released. And while I hear my colleagues about resources that are allocated to the National Assembly, and perhaps I acknowledge that, that has nothing to do with the section that we're looking at in isolation. That has to do with the allocation of resources that must come from the executive. So in addition to a proper legislative framework, there must be sufficient resources allocated to the National Assembly to get the job done. I acknowledge that. But you can't take the section and say, well, it doesn't make sense. You see, what it's trying to do is to balance interests and to ensure that there is an impartial arbiter that exists, which is the court. So those are my points on section 16. In terms of section 38, I believe, which has to do with prosecution. So in the ordinary course of things, any crime that is committed is investigated by the police and is then passed over to the to the Director of Public Prosecution for prosecution. So what this section is envisioning is two things, and it's not out of the ordinary. It's one, a simple report would be provided to the Attorney General in terms of a possible offense. That's a report. The Attorney General does nothing else. The Attorney General is not required to consent to a prosecution. Who is required to consent to the prosecution is in fact the Director of Public Prosecution, which I need to say this, that's already the case in terms of our constitutional framework. The Constitution of Belize provides that it is the Director of Public Prosecution who looks at evidence, who decides whether there is enough to institute prosecutions in Belize. So that's not out of the ordinary. And to underscore this fact, one must look at the rationale behind this section. The rationale is that in order to protect from political motivated prosecutions, one must escalate the matter to the DPP, who is given a level of great independence within the structure of the Belize Constitution. It's free from political motivation. The DPP is charged with looking at evidence, and if there is enough there, with bringing a prosecution. The third point that I want to address has to do with Section 22. Section 22 deals with an offense in terms of refusing to answer questions. Yes, there is a fine, but I must stress that that's conjunctive, and the other penalty is actually imprisonment to 3 months. And I think that's key to also point out. Madam President, I think those really are my points. I think, and I thank you.
Thank you, Senator Guerra. I recognize Senator Glenfield Dennison.
Obliged, Madam President. Madam President, can you hear me? Sorry. On this matter, Madam President, I just wish to make my position clear. I am clearly objecting to this particular bill, and I stand very firmly I'm not intended to legally advise this able body any further or offer my legal opinions, simply because the 1932 compensation of 1365 is now wholly inadequate to account for it. And if we're speaking about uplifting the privileges and making the parliament work, I think as the representative for the Trade Union Congress, we must ask at the very least ChatGPT how much $1365 in 1962 is today. And I will suggest very kindly, Madam President, that it's about what they pay a judge right now. That being said, Madam President, counsel who just spoke, my learned friend, said you can't say this section don't make sense. I'm here to tell the people of Belize the sections do not make sense. And they don't make sense for the following reasons. The Constitution is the supreme law of the land. And it is the Constitution that empowers the Senate to make these inquiries. There are guardrails in place, people of Belize. A motion for an inquiry has to be clearly stated, and the contents of that inquiry have to be clearly defined in that motion. So we're not on a fact-finding witch hunt. A matter of national interest has arisen. Senators have determined that that matter must be ventilated by their constitutional duty to the people of Belize. And it is in pursuit of that high duty to the people of Belize, for which we get $1,365 a month, that we are doing this work. And that work, in my time in the Senate, has been sidelined by the use of privileges that are now being updated to make it worse. So, let me address the last point, my friend. Well, the penultimate point my friend made. Section 38, let's be very clear. 38 will not function if there is no report produced. One, a report has to be produced to the Attorney General. That is an ultimate stop. You don't want a prosecution to go ahead, you don't produce a report. Simple. In the event you produce a report, you then need the AG to issue a certificate to say that the section has been complied with, and you, Madam DPP, can go ahead and see if you consent to this prosecution. So there are two layers before Madam DPP gets to decide whether there will be a prosecution. Two. That does not make sense. Section 16. I think my friend and colleague Senator Herrera dealt with 16 very well, and I don't need to repeat it. But the separation of powers requires, in my humble view, when the legislature is investigating a matter of national importance, that it is not fettered in any way by any outside agent, especially not any in the executive whose actions are being investigated. As it relates to the judiciary, people of Belize may not know, but these inquiries are time sensitive and can be terminated by the legislature simply closing down. Like we had an early election last session, that closed down our inquiry. Let's be very clear. So, we are speaking from experience to the people of Belize to say that this one can't fly. going to go and try to debate Crown privilege and why and so. I don't agree with my friend. For those reasons, Madam President, I will not be supporting this bill. I yield.
Thank you, Senator Glenfield Dennison. I now recognize Senator Gabriel Zetina.
Thank you, Madam President. I will make this very short because I believe my colleagues have stated one of the major concerns. A bill that, to me, goes to the very core of how Parliament functions and how accountability should be enforced, and how the Belizean people view this institution. And I must say from the outset that while I support modernizing outdated laws, I cannot support any law that weakens accountability, especially in a time when the Belizean people are clamoring for transparency and answers. When I took on this job, Madam President, I came along with my colleagues to seek what is best for the Belizean people. It is my constitutional right to do my job and to do it right. And Clause 16, to me, doesn't sit well. To me, this provides that a public officer may refuse to produce documents or answer questions before Parliament if an officer states that the matter related to unpublished on official records or to affairs of the state, unless a third party consents, in this case, the Governor General. And Madam President, if we're to be frank, it means that when the Senate summons a public officer, the very person or people entrusted with the public purse and the public authority, those officers may come to us and say, sorry, I just can't appear, classifying it as affairs of the state. That means Parliament has no power perception matters. Whether the drafter had no malicious intent, this matter was raised in a previous committee meeting by other senators. And so the question is, why was it ignored? When other parts of the bill was adjusted, was amended, and brought with those changes. And so while Senator Aguirre might be defending the drafter, to me, this is a deliberate attempt to leave this clause the way it is. If a public officer is being asked to answer questions, I don't think he should shelter behind a third party and classify it as affairs of the state. And so I will put it bluntly, I cannot support this bill in its current form, unless it is amended to ensure that the Senate can do its job and do its job properly, especially when we're seeking answers to alleged corruption, mismanagement of funds. I cannot lend my support to a legislation that does the opposite of that. And Madam President, I take this time to request for a division in our vote. The Belizean people expect this Senate to be the check and balance, not observers. And so we hope we can get the support of our other senators. Thank you, Madam President.
Thank you, Senator Zetina. I do not believe we have any other. Oh, Senator Pitts. I recognize Senator Sheena Pitts.
Thank you, Madam President. Just ensuring that you're hearing me.
Yes, Senator Pitts, we are hearing you.
Thank you, Madam President. Good morning, colleagues. Good morning, Madam President. Happy New Year to all my colleagues. I trust that the time off was rejuvenating. This morning, I like to commend the efforts to modernize the ordinance. I also commend the leader of government business for taking the time to meet with us, to solicit from us whatever our varying concerns on the bills were at that time. And what I can say is that it is quite unfortunate that we weren't all able to fully ventilate our concerns at that time. It is equally unfortunate that the concerns that were ventilated, they all, or most of them, the more substantial ones, were not properly reflected in this new iteration. And so in the greatest of effort, the time spent before now seemed to have gone for naught. And that is because we're now hearing how many of us cannot support the bill. I too join in not supporting the bill. And I do not join to not support it because it's not necessary. Updating the legislation is necessary. However, I think in the eagerness to make proposals and provisions to ensure that any future inquiry is effective, it is my humble position that the attempts were overzealous, and the overzealous attempts to ensure that any future inquiry does not repeat the kinds of things that we saw before is what is causing the proposed bill to have some difficulty. One, two, the overzealousness perhaps overlooked some of the caution that ought to have informed some of the provisions in terms of the constitutional backdrop. And three, what exactly is meant to be achieved by changing some of the provisions to ensure any future inquiry is effective? And in no particular order, I begin by saying the main objective would be in any future inquiry that where there is a question or information that ought to come before a commission, that there should not be any one person or persons who can conduct him or herself in such a way to prevent that information or disclosure to come to the commission. And so on the one hand, some of the proposals and provisions are geared towards compelling persons to do things in circumstances where they are constitutionally entitled to take a particular position without paying due regard to looking at objective means to ascertain and receive the information without the person. So for me, in the round, looking at the bill, I ask myself, does the bill do anything to assist a commission in receiving information or disclosure independent of persons who are entitled to take certain positions as of right? provided for in the Constitution? And my answer is no. And because of that, that is the reason why ultimately I cannot support the bill. Now, my colleagues before me have argued varying reasons why they couldn't support the bill. And there are some of the reasons that I can fully associate myself with for the large part. And there are my colleagues who have argued in favor of the bill. I take this opportunity to specifically say I cannot, will not associate myself with those views because those views are taken out of context of what the real perversion is of the bill, and it doesn't answer it. So when we legislate as legislators, we are to avoid ambiguity. To say that there is a term of art, a term of law that can be read or interpreted to mean one of two things is not good legislating. If the term can be defined, define the term and put it there. But even in the two definition, as has been proposed by Senator Guerra on what affairs of the state could or could not mean, what he failed to appreciate is that the perversion lies within the prerogative of the person to determine what he or she ought not disclose or should not disclose, and inviting the consent of a governor general who is not equipped or has the complement to assist her in affording a consent. And that is the problem. If it is the commission is meant to compel disclosure, then disclosure is absolute in terms of the subject matter, save and except for national defense or security and that sort of thing. So there is no term of art in law that can be foisted upon a political prerogative, because ultimately that is what it could be, whether it is a UDP administration or a PUP administration. And one thing we must never do, legislate in such a way that the very legislation could come back and bite you, use against you, or use in a way that does not meet the purpose. And I don't recall that in any iteration, the white paper was provided and any kind of rationale was provided as to why there was a change or a difference in using matters of the state versus public service. And I do not think it wise for any of us to hazard a guess. At this stage, as legislators, we must be specific. We must know. And so this is not the stage where I would say, Madam President, I am prepared to assume or I am prepared to glean from and say this is what it is, because what we ought not do and what we should do is guard against obvious areas of concern that we know later on will come back and frustrate the entire process. So we must pass this law today. There is some disclosure that is prevented, and then we go to court, however long that takes, for the court to say, I will take the term of law that means so and so, where there is no definition. I don't find that acceptable. And at this stage, we can do a little bit better than just rely on what we can assume, as opposed to make provisions for exactly what we want by simply adding a definition. So for me, separate and apart from that, the bill raises several credible constitutional and due process concerns. And that is when you assess it against the backdrop of our Constitution, common law principles of natural justice, and comparative Westminster jurisprudence. And I will just outline some of the aspects where there are concerns. Now, there are some things where it must be, there must be caution. There are some areas where it's constitutional vulnerability, and there are some areas where it's just offensive. The compulsion of witnesses and penal consequences. We've heard before us that there are penal consequences. A fine for recalcitrant witnesses, whether it's 750 or a fine and imprisonment. That is not for me the issue. The relevant provisions there would be 9 through 14 and section 22. The concern is on the separation of powers and procedural fairness. The bill grants the National Assembly powers that are quasi-judicial and coercive, compelling attendance, ordering arrest via warrant, examining witnesses on oath, and triggering criminal penalties for non-compliance. And while parliamentary committees traditionally have investigatory powers, the concern arises because the same body that initiates the inquiry also controls the summons process and determines materiality of evidence. There is no independent decision maker at the front end to assess relevance, necessity, or proportionality. And what has been established in the bill is that once the proceedings have commenced, the same rules that applies in a court of law is what applies there. Section 14 introduces High Court involvement for recalcitrant witnesses. That safeguard only arises after refusal, not before compulsion. And this creates tensions within natural justice principles, or I would say audi alteram partem, an impartial adjudication. And so for me, that is what we should look at if we are to proceed with the existing provisions. The arrest warrant issued without judicial authorization is another concern. The relevant provision is 12. The deprivation of liberty without prior judicial oversight. Section 12 allows the president, speaker, or chairperson to issue a warrant to apprehend a person if service is evaded or the person fails to attend. But this raises a serious constitutional issue under Section 5, protection of personal liberty. And the key problem is that the warrant is not issued by a judge or a magistrate, but by a political office holder. Judicial oversight only arises later, if at all. And in constitutional terms, this is a non-judicial deprivation of liberty, which courts in our Commonwealth jurisdictions scrutinize very closely. And those comparative systems are like UK and Canada, which generally rely on courts to enforce attendance rather than direct parliamentary arrest powers. In terms of criminal offenses determined by parliamentary opinion, and the provisions for those are section 14(1) and 22, the concern is about the vagueness and the arbitrariness. Whether a refusal to answer constitutes an offense depends on whether the president, speaker, or chairperson considers the question or document material. And that raises two due process issues: subjectivity, materiality is not objectively defined, and two, lack of predictability. A witness cannot reliably know in advance whether refusal is lawful. Criminal liability that hinges on political or discretionary opinion rather than clearly defined legal standards is constitutionally problematic. Now, immunity from court jurisdiction. The relevant principles are 3, 4, 6, and 7. And I recall during the sessions with the leader of government business, he did direct his mind to developments in law in terms of how immunity is treated and how wide it can be, or the constraints it is now being looked at. I do not see, and please help me, leader of government business, whether or not the case law you directed your mind to and the relevant provisions being 3, 4, 6, and 7, if looking at the jurisprudence there, it matches up soundly with those sections. Now, the access to the courts. 3 excludes the president, speaker, and officers from court jurisdiction for acts done under the Act. Combined with Section 7, which is a restriction on service of process, this raises concerns under Section 6 of the Constitution, which is protection of the law and access to courts. Now, parliamentary immunity is constitutionally recognized, but absolute or near absolute immunity risk exists. So shielding unlawful or abusive exercise of power from judicial review or undermining the constitutional role of courts as guardians of legality. Our courts, and this is a general statement, we can't speak to what our jurists would do, but the courts are likely to read these provisions narrowly to preserve judicial review. But the drafting invites challenges. So it is better for us at this stage to take a step back and a sober look to see how it is we can revisit some of the provisions that would make absolute clarity or remove itself away from the concerns that will be inevitable should it get to the court stage. In terms of evidence inadmissibility and control over disclosure, relevant provisions being Section 17 and 18. The impact on fair trial rights. 18 broadly excludes parliamentary evidence from admissibility in courts unless permission is granted by the president or the speaker. The potential constitutional issue there is that a criminal defendant or civil litigant could be denied access to exculpatory or relevant evidence because permission is withheld by a political authority. And this conflicts with fair hearing guarantees under the Constitution and the common law right to make full answer and defense. The absence of express proportionality safeguards, and these are structural relevant observation. The bill does not expressly require that summonses be reasonable or proportionate. Less intrusive means be considered or reasons be provided for compelling specific witnesses. And modern constitutional jurisprudence increasingly requires proportionality analysis where fundamental rights, which like liberty, expression, and privacy are affected. So the bill raises these constitutional and due process concerns regarding deprivation of liberty without judicial authorization, criminal liability based on political discretion, weak front-end procedural safeguards, potential erosion or access to courts and fair trial. There are many provisions that are still defensible in principle within our Westminster parliamentary framework, but we should not legislate in such a way that we cause courts to read down aggressive clauses to preserve constitutionality. And so the greatest constitutional vulnerability should be addressed before we think to pass any such bill. And on the criticisms of Section 16, Section 16.2 particularly, I associate myself therewith. And if it is we are to take a particular position on what words and phrases mean, it is our responsibility to properly define them. And we are at the appropriate stage where we can legislate responsibly. And so I think if it is, if it can be saved before we just turn down the bill, we pull it back to say we work on it. But in its current form, Madam President, I do not support the bill. Thank you.
Thank you, Senator Sheena Pitts. Leader, a recognized leader of government business.
Thank you, Madam President, and thank my colleagues for their informed contribution to the debate. Let me start by saying I believe it is right and fair to say that all senators support the modernization of the legislative framework that governs our activities. And so we have a common interest in ensuring that the bill enjoys our support. And in doing so, it's necessary to make sure that it is effective. In addition to some of the comments that have been raised so far, Madam President, for me, there are a number of other, perhaps less substantive, but in my view, necessary provisions that need a second look, or perhaps a third or a fourth look. With us members to look at the definition section, simple things like the definition of member, which means a member of either chamber and in relation to the House includes the Speaker, but doesn't mention the Senate. If you look at the definition of Speaker, it says Speaker means the Speaker of a House and includes the Deputy Speaker and any member for the time being presiding over the House. When you look at the definition of President, it says President means President of the Senate and includes any member of for the time being presiding over the Senate. Doesn't mention Vice President of the Senate. And I think if we are going to deal with these matters on an equal basis and respect both houses, those two clauses need to be addressed. Clause 5, no member shall during a session be liable to arrest or imprisonment or any civil process except for a debt which constitutes a criminal offense. That latter phrase, I'm not sure what it means. And I think we need some guidance as to whether that is what is intended. When one looks at the Legislative Assembly powers and privileges bill, it's much ordinance, it is much simpler. And I suspect there may be a merging of two concepts here that results in what appears to me to be a provision that is unclear. Madam President and colleagues, if we can go to clause 14 of the bill. And specifically clause 14.4. A person who fails without lawful excuse to comply with an order made under subsection 3, which is an order of the High Court, commits contempt of court and may be proceeded against and punished accordingly. And this goes to one of the points that was raised by Senator Pitts. This whole issue arises in Parliament, and it is someone who is disrespecting Parliament. In order to introduce some independence, the question is referred to the High Court for the High Court to determine whether or not that person had a lawful excuse. If a person doesn't have the lawful excuse, in my view, it is a contempt not of the court, but it is a contempt of Parliament. Not because the court made the decision, it means that you're being contemptuous of the court. No, you're going through the process of the court to find out whether you had lawful excuse to take the position you took before Parliament. So again, I think that needs to be clarified. Again, when we go to clause 15, I am interested to hear the rationale for this. I listened very carefully to Senator Wade's explanation and the factual matrix that he painted. I just say that one has to weigh against all of that the right of a person to choose his or her attorney. We can deal with that at a later date. When it comes to 16.2, in addition to the very substantive criticisms that have been leveled, I would add a question. And I heard Senator Guerra giving the rationale that he did, but I wonder whether the Governor General is the appropriate functionary of the state to be called upon to make this decision, because this decision is justiciable. And so you will be having cases against the Governor General where persons disagree with her decision one way or the other. Because it is likely to have some political flavor, i.e., some government is saying, I'm not going to release this. It may emerge out of some investigation into some government malpractice. So you're likely to have stakeholders, opposition saying, release this document, provide this evidence, and the government trying its very best for political reasons not to do so. That political debate, the hurly-burly of that debate, will have the Governor General at the center of it. And I don't know if that is where we want to go. Affairs of the state, again, we have to take a look at this whole section and to ensure that things that ought not to be in the public domain are not put in the public domain. That is not inconsistent with disclosure. Disclosure, as my colleague attorneys will know, is sometimes made in court in what we call in camera. So if there is a sensitive national security issue that the Senate is genuinely investigating, and it needs to hear from the Director of National Security, the Commissioner of Police on a sensitive matter, it may be able to say, I'm holding a private meeting, and that information is then given on the basis of strict confidence that it will not emerge in the public domain. So we need, in my respectful submission, to revisit this section to achieve a balance between disclosure and protecting what is genuinely in the public interest. Very quickly, clause 22. I think 22B refuses to be examined before or to answer any question put by the Chamber or committee. We have to introduce without lawful excuse into this. It appears in another section, but it has to be inserted here, in my opinion. Two more comments, Madam President. And I would just say that I don't recognize the rationale for the various fines. They don't seem to be consistent to me, but without going into that at this point, it's something I think that needs to be addressed. What I don't understand is clause 23. In clause 23B in particular, as it is worded, it does not appreciate that people, not everyone takes an oath. Some people might want to affirm, some people might want to do respect for some other religion. And when you look at A and B, it says a person who, in the course of giving evidence before the committee, willfully makes a statement material to the subject matter before the chamber or committee, knowing a statement to be false or not believing it to be true, commits an offense. And if the statement was made on oath, is liable on conviction on indictment to imprisonment for 7 years. B, if the statement was made otherwise than on oath, liable on conviction by a court of summary jurisdiction to a fine of $3,000. Well, everybody is going to say, I'm not going to swear on oath, because the exposure, if you affirm, is less, far less than if you take the oath. And I don't think that is the intention of the section. Madam President, colleagues, finally, clause 37. For the purposes of this act, it shall be lawful for the person who fills the office of Speaker at the time of the dissolution of the House to exercise all powers conferred by this act on the Speaker until the House is again summoned. It has forgotten the President and the Senate. So where does that leave us, Madam President and colleagues? Clearly, the bill does not enjoy the support of the Senate. I will not, Madam President, ask that the question be put. I will ask that the matter go to committee so that we can re-engineer and hopefully reach a consensus. I say one thing to colleagues, and I don't say this I say this merely for us to bear in mind that some expedition is needed. Until a new bill is passed, we are operating under the Legislative Assembly Powers and Privileges Ordinance with all its defects. So I say expedition, and let's work in a cooperative way to try to fix this and send it back to the House with the support as broad as possible of the Senate. Madam President, I ask that this matter be left in committee for further examination by senators.
Thank you, Leader of Government Business. The bill will be referred to the committee for further examination and consideration. I recognize the Leader of Government Business.
Madam President, I move this. With your permission, can we take the next two bills together?
You may proceed.
I move the second reading of a bill for an act to appropriate further sums of money for the use of the public service for the financial year ending the 31st day of March 2025 and the General Revenue Supplementary Appropriation Bill 2025-2026. Madam President and colleagues, these two bills are, as we are all aware, late. It has been before the Senate for quite some time, and even when they came before the Senate, they came at a late time. We are virtually near the end of the financial year, and we are in duty bound to address the bills at this stage. The reason why it's being done at this stage, of course, is because on the last occasion, our debate did not allow us to capture or to attend to the other bills that were on the other paper. I would like to just give a very brief overview of these two bills. There is no doubt, Madam President and colleagues, that we are dealing with an astronomical amount of money. $210 million worth of public funds, for which approval in some cases is being sought retroactively and in some cases prospectively. Under the first bill, the total amount to be appropriated is $131,694,601, which is made up of $30.4 million of recurrent, $74 million of Cap 2, and $27.2 million of Cap 3. Under the second supplementary appropriation bill, the total amount appropriated is $78,752,546. That is broken down into $20.5 million recurrent expenditure, $49.25 of Cap 2, $49.25 million for Cap 2, and $9 million for Cap 3. Without going into the details, because I'm sure colleagues will go into this in detail, Madam President, there is a combination of salaries for public officers and security officers. There is expenditure in health in the University of Belize, the Ministry of Sports, and passports, for example. Most importantly, there are investments for increase in the police department and for the Ministry of Rural Transformation, Community Development. The blue economy, Madam President, and disaster risk management is getting an additional 1.5 million. A substantial amount of road works is programmed in these two bills throughout the country. In San Ignacio, Enquevejo, Santa Familia Bridge. We have the Orange Walk Town to Kenny Grass, Bullet Tree to Spanish Lookout. Substantial amount was appropriated for the National Assembly retrofit and for Ladyville road work. So there is a significant amount of funds being spent out of CAP 2. When it comes to CAP 3, Madam President, again, we have roadworks, social investment fund, sustainable development, etc. All of these expenditures are monies which we are required to bring to the National Assembly for approval because they were not approved in the original supplementary, or not supplementary, the General Revenue Appropriation Bill, which we passed last year. As I said, Madam President and colleagues, this is required by law, and late though it is, we have brought it so that the National Assembly, and in this case, the Senate, can examine the appropriation figures and I hope support it. Thank you, Madam President.
I recognize Senator Patrick Farber.
Madam President, if I may seek some clarification before I get into my comments on this or these two bills. So it is that when you ask for a vote, that vote will go for both of these bills since they're being taken together? Is that the intention?
Leader of Government Business.
I'm in the hands of the Senate, Madam President. We can either do it together or we can do them separately.
Well, we had agreed that we would move them together.
That would be
Senator
my
Farber?
preferred position.
Well, the reason that I would object to that, Madam President, is that we've already seen a trend when these bills were debated in the House of Representatives. In fact, the government went to great strains to paint the leader of the opposition as not supporting elements of one of the bills simply because things were lumped together in a format now that is being increased when they put the two bills together. And that was, in my view, very reckless on the part of the government, and I would want to stave off any such blame, if you will, and lumping together of all of these issues simply because you might not support one element. There may well be some good elements in one of the bills that you want to support and that you don't want to support in the other one. And so, to me, this is not the right way to do it.
Let me say, Senator Farber, that while we will debate the bills together, the questions will be posed separately. So there will be two separate questions posed for two separate bills.
So you'll get to share your ayes or nays on each bill individually.
Absolutely.
But it will be debated together.
Yes.
Guided, Madam President.
Since the commonality is the appropriation bill.
Guided, Madam President. So, Madam President, to me, there are two major things that come out with these appropriations. Firstly, it can mean that the government has not planned properly. And I hasten to remind colleagues or to make colleagues aware, if they are not yet aware, that in fact, when it is we bring the supplementary appropriation, the one for 2024-25, that this is number two. This is number two. And we cannot lose sight of the fact that there was, during that same financial year, an allocation and a supplementary appropriation that was a whopping $106 million. So if you add that 106 million, Madam President, to the 185 million that the second appropriation supplementary for that same financial year brings, then we're at $185 million over what is budgeted. I don't even know, Madam President, if this is legal. The leader of government business makes the point that they're obliged to bring these matters, and I will agree with him wholeheartedly on that matter. And in fact, my experience in the lower house of the House of Representatives will show that in the past, both political parties that led our government neglected to bring these supplementaries on a timely manner. I remember one time, Madam President, under the leadership of the Right Honorable Dean Barrow, that they brought a slew of supplementaries, probably about 6 or 7 for years, that covered both the PUPs and the UDP's term in office. So when it is that the government identifies as a priority bringing these supplementary, I say kudos to that. I don't want to take that away from them, but the manner in which these bills are brought suggests now that they lack the proper planning. They are incompetent, Madam President, when it comes to putting together a national budget for this country. It is either that, or, Madam President, it is that they are purposefully trying to present figures at the time of the budget presentation to have the budget look rosy and cozy, if you will, and then later on come with these huge supplementary amounts to fix the problems that were ignored when they created the budget. The schedule before us, Madam President, authorizes additional spending for the 2024-2025 number 2 Act of $78.7 million. And when we look at the breakdown of this, Madam President, we see recurrent expenditure of $20.5 million, Capital 2 expenditure of $49.2 million, and Capital 3 expenditure of approximately $9 million. And if you look at these figures, Madam President, these aren't marginal figures. And again, I remind that this is the second supplementary after, in fact, a $130 million supplementary had already been passed in this same year. On the recurrent side alone, Madam President, what we see in this particular bill, and I'll get to the second bill for 2025-2026 in due time, but in this particular bill, we see the Ministry of Finance accounting for over $10 million in additional spending. And you know, Madam President, this is why we need to look at these bills, in my view, independent of each other. Because you heard what the leader of government business says. He talks about the increase in the recruitment of the police officers. He speaks about the increase in healthcare workers. He speaks about the 4.5% salary increase for teachers and public servants. And he would have you believe that this initial amount of $79 million added to the $130 million, if you don't pay attention to the figures, you'd believe that that is the cause for these things. But independent of that, even before we look at the supplementary coming for 2025-26, which include those things that I just mentioned, this government overspent a whopping $185 million. Reckless. It's either incompetence, again, Madam President, or they're intentionally trying to mislead the Belizean people. And then, of course, we can't forget that this was an election year. So it's a year when, of course, we saw people do in the government all sorts of things in order to try to secure the election victory. And I will get into more of that as I proceed. But The Ministry of Finance alone, Madam President, was over $10 million. We saw other increases in health, in foreign affairs, in home affairs, in rural transformation, and in the Office of the Prime Minister. And for those who aren't aware, the Office of the Prime Minister holds the Community Development Fund, which from time to time is bumped up so that representatives can handle their people with whatever is at stake from time to time. None of these things that I've mentioned, though, Madam President, are new obligations. These are core operations of the government: the Ministry of Finance, the Ministry of Health, Foreign Affairs, Home Affairs, Rural Transformation. They are not new ministries. They're not something that they created so that once the budget was actually being presented in March or whenever it was of 2024, that they could not foresee that these expenses would come up. In fact, again, I point out, and I will keep pointing out, that this is the second supplementary. So they already came, and it would be interesting if we had the time to go back to see what that 130 million in the first supplementary was spent on. Because even after you allocated additional funds for those areas, you'd have to come back a second time in the same financial year to say that you didn't get it right and to ask for more money from the Parliament. Then, Madam President, there are recurrent items like personal emoluments, operating costs, utilities, travel, materials, and grants. Again, these are predictable expenses. So when they were making the budget in March of 20, or the process begins much earlier than that, when they were sitting down to decide on what would be spent in the 2024-2025 fiscal year, they did not know, Madam President, that they would need to have certain emoluments. And in fact, this is an area that we should watch carefully. In fact, in all of the ministries, personal emoluments went up, all of them. I think the judiciary, one we could understand, because I know that there was some clamor from the judiciary for increases, and we saw for the Court of Appeal $422,000 increase in terms of what we pay to the judges. But in the other areas, Madam President, every other ministry, national security has additional personal emoluments in this supplementary. The Office of the Auditor General, additional emoluments. The Ministry of the Public Service and Constitutional and Political Affairs, additional emoluments needed. The Ministry of Finance, the Ministry of Health, oh my goodness, every single one of the health facilities managed by the government of Belize needed additional personal emolument money. The Central Health Region, San Ignacio Community Hospital, Northern Regional Hospital, Corozal Community Hospital, Southern Regional Hospital, Toledo Community Hospital, Western Regional Hospital. Every single one of these entities required more money to pay salaries. So what was going on, we can only guess. And it's obvious, you know, Madam President, it seems that they went on a rampage to offer people jobs because the election was coming. We have to suppose that that is it, because if it is not that, then they would have to concede that they don't know how to plan, and the whole plan Belize shenanigan is just a joke. We saw, Madam President, where we saw for the police, we see again for the Attorney General's ministry, increase in personal emoluments. We saw almost every district fire service increase in emoluments. The National Fire Service of Corozal, the National Fire Service of Orange Walk, the National Fire Service of Cayenne. I'm not saying that these entities do not require additional support, if it is done in an organized, structured way. But this is clearly no structure. This is clearly something that is being done, in my view, Madam President, because it's election and they feel that if they offer the people the jobs and so on, that this will help them to win the election, and maybe it did. But it is reckless on their part. On the capital side, Madam President, we see even more striking numbers. We see Capital 2 allocations exceeding $49 million. We see significant sums of money directed to infrastructure, to road, to bridges, to public buildings, to vehicles, to digitization projects. And again, the leader of government business has trumpeted that these were good things, and ordinarily we would probably agree, but why was it not planned for properly when you made the budget for the fiscal year 2024-2025? In Capital 3, we saw a further $9 million tied to infrastructure projects and loan-related expenditures. And again, this is money for projects that have international funding. And so you didn't know that these commitments were there. None of this spending, Madam President, is emergency funding. They did not arise overnight. And again, I remind, this is the second supplementary. They already had come back for $130 million. Roads don't suddenly need upgrading without prior knowledge unless there was some kind of natural disaster. Buildings don't unexpectedly require millions of dollars in improvement without planning. Vehicles, equipment, large-scale projects are not surprises, Madam President. Proper budgeting requires that these costs be identified long in advance, that they be costed, and that they be presented during the main budget exercise that typically happens between November and March of the fiscal year. The sheer scale and composition of these supplementary appropriations, Madam Speaker, raise serious concerns about how the original budget was prepared. And I hinted to that, but I have to wonder if that process has any validity, if you have to come back and we see the trend clear now. I mean, the fact that these supplementaries are late give us the opportunity, Madam President, we'll see two of them together here, but it comes so close that in fact we can remember the first one of 2024-2025 being $130 million. And while we near the end of the current fiscal year, I don't know, maybe the rush to now see it through, Mr. Leader of Government Business, may well be because we have some surprises coming, another surprise coming when the session of Parliament resumes next month. I wouldn't be surprised. Why I hinted, Madam President, that it may be illegal is because the Finance and Audit Act governs how public monies in Belize is spent. And it establishes the national budget as the primary financial plan of the government. It allows for special warrants only in cases of urgent and unforeseen expenditure. And again, this kind of spending that the supplementaries bring don't fall in that category at all. But even when that is triggered, Madam President, under the Finance and Audit Act, even then the law limits such spending to 10% of the allocation for a specific head of expenditure. And so while the government quickly says, yeah, we are doing the right thing, governments in the past didn't do it, and you are right, I concede again, both political parties in the past were not quick. And I will give the administration kudos again for bringing these in a relatively timely manner considering what was done in the past. But they neglect to tell you about the limits that these supplementaries can have. I don't think anybody is paying attention to the fact that, yes, the Finance and Audit Act says that spending must be within 10% of the allocation for the specific head of expenditure, I am willing to bet you that if you look at the 2024-2025 budget that was approved, that if you combine what is in this first supplementary allocation of 130 million, and with the almost $80 million that this second bill brings, that you will see that some of these specific heads of expenditures have far exceeded the 10%, making this kind of spending completely illegal, or certainly against the Finance and Audit Act. I'm willing to bet that that is the case. But they pound their chests, Madam President, and say, well, at least we're trying to do something here. At least we're doing it in a better way than previous governments did. Never mind what the Finance and Audit Act says in its specificity. What the law does do, Madam President, again, is also impose an overall cap on how much the national budget may be exceeded once Parliament approves supplementary appropriations. And if we assume that, well, let me not even go there. Once the Senate and the House approve the supplementary schedules, Madam Speaker, the spending then becomes lawful. But legality, Madam President, is not the only, it's not the same, I should say, as good governance. The Finance and Audit Framework assumes that supplementaries are exceptional spending. It assumes that the main budget is credible, and we can say that whenever this government puts forward, given the amounts of monies that they've come for when these issues are not emergency issues, dictate that, in fact, Parliament did not produce, or the government did not present for Parliament to approve a credible budget. It assumes, Madam President, the Finance and Audit Act does that the Parliament will not be asked repeatedly to fix what should have been done properly the first time. And suppose it was that they had brought 15 million or 10 million and they have a second one of a, no, these are huge sums of money. I think the leader of government business conceded that quite readily in his opening remarks, that these are large sums of money for things that are not accidents, that are not emergencies. So whenever they try to paint the picture again that they present credible budgets, Madam President, these supplementaries now exist in fact. Two from 2024, 2025, but the fact also that there is no one for 2025, 2026, the possibility of another one coming before the financial year is over, suggests that the assumptions that their budget is credible, that collapses right away, Madam President. We are told repeatedly, they sing it like a song, that they have a proper plan, Plan Belize. Plan Belize 1.2, Plan Belize 2.2. They talk, Madam President, to a nauseating level of how well their plan has operated. But what we've seen here, and what these supplementaries do, is just show how weak their Plan Belize is. We are told that the plan guides priorities and spending, yet the numbers before us, Madam President, tells a completely different story. A strong strategic plan should reduce uncertainty. It should improve forecasting. It should align policy objective with realistic costing. It should minimize surprises, Madam President. But instead, the repeated supplementaries expose weaknesses, not strengths. They show that the ministries did not accurately estimate their needs. They show that the major capital projects were not properly integrated into the original budget. They show that the budget exercise has become disconnected, very much so, Madam President, from any reality that we face in this country. This is compounded, Madam President, by the tendency to deflect responsibility, references to what previous administrations did or failed to do, and prepare to hear Prepare to hear Senator Guerra jump up and talk the estimates. In fact, when they first got into office in the midst of COVID, they completely trashed the existing budget that was there, claimed it was not real, and so they had to do their own thing. Well, since that time, Madam President, they've had 4 or 5 occasions now to present their own budget. And even with their own budget presentation, it signals that they are either lost, confused when it comes to budgeting, or purposefully trying to mislead the Belizean people. These repeated supplementary appropriations, Madam President, undermine the public trust. They weaken parliamentary oversight. There is an intention for why these bills, the supplementary appropriation bills, are brought to the House. It is so that the House can properly oversee the spending. There is a reason why the budget is presented, the General Appropriations Bill is presented to the House of Representatives on an annual basis. There is a reason for that, because the Parliament should have oversight on spending. But rather, we are now seeing that these things come to us after the fact. And we are seeing that they come to us in a reckless kind of way, not taking into consideration the true situations that would lead to real and credible budgeting. And then we get these huge supplementaries afterwards. The budget, Madam President, must not be a stage for grandstanding, must not be a political performance followed by quiet corrections months later. And if you don't look in the details, I noticed that, you know, Madam President, that they gave us the bill. And maybe I should be kind and say that it was oversight, because I know that my friend, the leader of government business, does his best to be transparent in terms of giving us the documents. My friend, Senator Chris Curry, also, when he was Minister of State in the Ministry of Finance, does not hold back in terms of sharing information, having sessions, and so on. But they gave us this bill with just the overall figures, but the details of the schedule, they didn't give to us in this House of the Senate at all. So you had to have your own connections to get the details of the supplementary spend. I don't know why that was done. I think I got mine from a member of the House. Wasn't given to us in our papers.
Madam President, just to correct the record, they were circulated to all senators.
Well, I'm not sure about that. But the budget, again, Madam President, should not be used as grandstanding. And I will yield to the leader of government if he says so, because as I've said before, I don't see him as the kind of individual who purposefully withholds. In fact, when I've often lamented that in the House of Representatives, we don't get to see a lot of the details of stuff. And since coming to this upper house, I have seen a greater willingness on the part of those who operate on behalf of the government to provide information and documentation. So let that not be an issue, my friend, the leader of government business. I take what you have said. There is no statutory cap. And in the absence of that statutory cap on total supplementary spending, parliamentary scrutiny becomes a primary safeguard. Senators must ask why these expenditures were not anticipated. That should be the big question on our mind. But they will try to song and dance you, especially through the next appropriation, supplementary appropriation, the one that sees 4.5% increase in salaries for teachers and public servants. They will try to to say to the nation, look, just support this because this brought something good. It's brought something good. In fact, they should be ashamed, Madam President, that they had not made allocations to give to the teachers and public servants much earlier. In fact, it was under force. It was when you were jacked up by the unions that you were forced to put this in. And so if this particular issue stood alone, the issue of the teachers receiving the 4.5% and the public servants receiving the 4.5%, if the matter of the increase in police could stand on its own, then we could quite easily support these supplementaries. But unfortunately, you have lumped it in here with a lot of other unnecessary and improper spending, and the devil are in the details, I am sure. We need, Madam President, to take back the integrity of our budget process. We need to restore seriousness about budget preparation. We need to strengthen internal planning and coordination across ministries. In fact, I don't think that anybody in this chamber will dispute, Madam President, because I get the sense that we're more willing here, and especially those from the government side, they're more willing here to own up to some of these problems that we are genuinely pointing out in order to make governance of this country easier. Whatever exercise happens from November, is it, or earlier in the financial year leading up to the presentation of the budget, normally in March, is a charade. But when you add to that those natural, or maybe they're not so natural, but those existing deficiencies of the system, when you purposefully add to those deficiencies in order to hoodwink the Belizean people, that's where the concern becomes even greater. But we can start by making the system as it exists more accountable and more functional. We can present conservative and realistic estimates, Madam President. We can treat supplementary appropriations as true exceptions, not routine tools. We can use the budget to govern and not to perform. As I've said, Madam President, we need to take back the integrity of our budget process. We need to take back the idea that these numbers matter. We come here, we just spew the numbers, 78 million, 130 million, and by tomorrow it is forgotten. Belizean people need proper accountability, and they need for us to be good stewards. The Finance and Audit Act allows what we are seeing, but it does not excuse it. The law sets the floor, not the ceiling, for good governance. Belizeans deserve better than repeated corrections and shifting figures, which is what these supplementaries represent. They deserve, Madam President, credible budgets, disciplined execution, and honest accountability. That, Madam President, is the standard that we must, as parliamentarians, insist on. A deeper examination, Madam President, of the supplementary number 2 for fiscal year 2024 reinforces the conclusion that this is not incidental or emergency spending, but it is a systematic, Madam President, a systematic correction of omissions from the original national budget. The scale, the composition, and the predictability of these items point squarely to either intentional concealment at budget time, or again, serious incompetence in fiscal planning. And let's look at the judiciary, Madam President. Again, one of the most stable and predictable arms of the state. The Court of Appeal received supplementary allocations of $180,000, $242,963 under personal emoluments, and I went over this again, and maybe there are good reasons for that given the insistence of the judges, but we must have been able to plan for this. The judges never just wake up and start to agitate, just like the teachers and the public servants never just start to wake up and agitate. If you're a responsible, productive government, you would have foreseen these things and planned accordingly in the national budget. Their contracts, their remuneration and allowances are well known in advance. These sums were required to meet existing obligations. Then the original budget knowingly understated the true cost of running the courts. And if you don't apply this to the judiciary, apply to every other sector where emoluments have gone on. The Auditor General Department presents an even clearer example, Madam President. Belize City, under this department, required an additional $186,552.25 in personal emoluments. Don't know why. Belmopan, another $45,593.24. The irony here, Madam President, is unavoidable. The very office charged with auditing government's financial management and should whip the government into shape and say, listen, do the right thing and present the right figures and be accountable, has evidence, Madam President, of budgetary mismanagement. Staffing structures in the Auditor General's department are neither experimental nor volatile. Either the Ministry of Finance failed to capture its own payroll accurately, or it deliberately deferred these costs to be regularized later through supplementary approval. And let's look at that deliberate intention for a minute, because the question might arise, why would they deliberately do that? Because, Madam President, because the government and the Prime Minister likes to paint a rosy picture when the budget comes around. If you listen to him, everybody is working. If you listen to him, there's very little inflation. If you listen to him, the economy of our country is booming. Everybody is booming. Nobody is left behind. What was their catchphrase during the 2020 elections? Everybody for win. Well, everybody is clearly not winning. What you could have used in a grocery store, what you could have gotten for $100, the simple things have increased, have doubled in price. Something that used to cost on $2, $3 now costs $7 and $8. But if you listen to the Prime Minister, you listen to them when the time comes, when he presents the budget, everything is rosy, rosy, rosy. So there is intent, in my view, and in many of the Belize residents' view, Belizean citizens' view, that the budget is only intentionally made to look good, and then later on we receive the real repercussions of what is happening in our economy, and then we try hurry it through, like we're trying to do today. Put the two bills together, lump all of the thing then, and just we have to get it through now. And whether it came today or it came 3 months ago, it still describes what I'm saying. Still very much describes what I'm saying. If we look at the Ministry of Health and Wellness, the pattern repeats itself, Madam President. Almost mechanical consistency again. Central Health Region, Northern Region Hospital, all of them people require additional emoluments now. The most politically sensitive example appears, though, Madam President, under the Ministry of Home Affairs and New Growth Industries with the police recruitment, $2.2 million. And I say it's politically sensitive because you would think, in fact, what they will say, I can tell you what they will say. You'll hear my good friend Senator Guerra jump up in a minute. You'll hear the leader of government business. You might hear others tell you, well, this is needed because crime is so much out of hand. It's a band-aid fix. It's a band-aid fix because you're not targeting the root causes of crime. And don't tell me about what the last administration do either. You wanted the job. And in fact, you said, I could hear Karimu saying in my mind from before 2020 to talk about all that could have happened. And what has he done? And what has the government in general done to curb the problem of crime? Put more police officers out there. with a little bit of training.
Could you check to see if my thing is different?
A little bit of training. I'm hoping that it will solve the problem. It's cosmetic. So we dare not, and I caution any other senator who will come after me and speak. We'll not talk about that 2.2 million when they put for police, because if you talk about that 2.2 million, it would mean that you're against the crime fighting efforts. You're talking against the police officers. That's what they will say. But the truth of the matter is, even with these additional allocations, crime not gone down. I don't care what the commissioner of police say with their statistics. In fact, just over the weekend, 12 shots were shot right outside my door in the middle of the night. 1:20, I was awakened by 12 gunshots popping off, ringing off right within 100 yards of my door. In fact, 5 feet away from my vehicle parked on the street. And I reside on the north side of Belize City, in a neighborhood that is supposedly safe. No $2.2 million when it gives to the police, 1.52 in personal emoluments, and I don't know where the other 2.2 million, I guess, for something for the police. It's not making anybody safer. I spoke about the fire service already, Madam President. The Ministry of Finance itself, though, under general administration, more than $8.5 million in supplementary funding was approved. These are the things that are very blatant. Look, monies that are now approved to cover travel and subsistence, I think about $500,000. This should be a crying shame. Multiple tranches for operational costs, maintenance costs, $4.5 million for contributions and subscription. Nothing where we just giant either, you know. And you say, well, the UDP didn't take these matters very seriously. So we have a lot of back payments for subscriptions to these entities that we belong. Well, you may know that 5 years ago. Why wasn't it put in the budget in March of 2024? Then there are routine things like electricity bills. Again, official travel. These are not unforeseen contingencies, Madam President. The fact that they appear in these supplementary appropriations bill confirms, it tells us that the original budget did not present a full and honest picture. Either that, or they're now increasing travel to gallivant all over the world. This is a very traveling government, that's true. They travel all over the place. In any given week, 4 or 5 ministers, they're all over the world. You don't believe me, check for yourself. But they tell the teachers and the public servants there is no money for the increase. The Prime Minister absolutely said there is none. And they withheld as long as they could have. Before you jump up and talk about the UDP record, the UDP, for the record, gave the teachers of this country and the public servants a salary adjustment of over 30%. That is the record of the UDP, in case you want to talk about it. It was planned in incremental phases. The only time that the teachers gave the government trouble, I think there was a hurricane or something, and the Prime Minister attempted to say, well, we can't pay this year, and that was the trigger, because the Prime Minister said we have these other expenses because of a natural disaster, and we can't make good on the portion of the adjustment that you asked for. That's not the case with this government. They didn't plan to give the teachers anything. They didn't plan to give the public servants anything. That's a fact. So when you come now and you present in the second supplementary these figures, and you say, well, the government is doing this for the teachers and public service. You lie. You never intended to do that. I will just highlight again Madam President, in order to save time, because the same argument applies for the second supplementary appropriation that is before us, that of 2025, 2026, and this one I think is even more. One has even more money, $100 and odd million again, another $100 and odd million. But they will say had to do with the teachers increase and other increases. But I will stop there, Madam President, and be kind. I think you all get the gist of what I'm saying. We must be more responsible in terms of the budget process. We must make sure that we hold the government accountable to producing a proper budget. We must make sure that we don't bring or take the process of bringing these supplementary appropriations as just a formality, and we use it to be disingenuous to the Belizean people. We should never, ever do that. And if anybody, if ever there is an entity, even though we can't stop the lower house from matters having to do with the finances of the country, if anybody can make a pronouncement on what has gone so terribly wrong in terms of budgeting in this country, the actual general appropriations bill and these supplementary bills, I will be willing to bet that it is this House of the Senate. Anybody can get the Belizean people thinking. Because you know, Madam President, I am now sold. I'm now sold that this is the more responsible of the two houses when it comes to the national matters of the country. Again, we saw in very brilliant display just now again where the government did not get its way. Senator Courtney will put that a different way, of course, in that he was a part of offering some of the criticisms that he felt needed to be fixed. But what we saw was that particular bill that we just debated being stopped in its tracks until we can get it right. And so I implore my colleagues from the government side and also those who are non-affiliated to political parties to ensure that we do what we need to do, make our contributions in order to correct what I think is a gross injustice to our country's role, or the gatekeepers of accountability and professionalism. We have a duty to do. Let us perform that duty with all the vigor that we can find, my fellow colleagues. Thank you, Madam President.
Thank you, Senator Patrick Faubel. I recognize Senator Kevin Herrera.
Thank you, Madam President. I'm still adjusting to this virtual setting. Madam President, allow me to just make a few remarks on the two supplementaries that are before us. I'd like to state before I start that I want to look at it at a high level rather than getting into much of the details that would be contained in the detailed submission that was sent along with the papers, Madam President. But more so, Madam President, I want to raise the issue of the various balance that we try to achieve when we're presenting these budgets. And I'll address the 2024-2025 one first, Madam President. The budget was for $1.5 billion and in revenues. There was a total of 1.6 billion in projected expenditures. And then in terms of recurrent expenditures, there was $1.17 billion. Madam President, under Cap 2, there were 276 million projected, and Capital 3 was 146 million projected. Now, what we have before us, Madam President, today is 20 million, 20 million, and I can't say proposed because this has been spent already. $20 million. This represents a 1.7% increase over the recurrent expenditures projected in the budget. Under Cap 3, it's for the we have the supplementary that is before us is for $49 million in Cap 2, and that represents a 17.8% increase over what was presented in the budget. And then under Cap 3, there's an $8 million proposed, and that again represents 5.4. So the overall figure, Madam President, is $78 million. I think that both Senator Courtney and Senator Faber went over those. Now, this $78 million represents 6.6% increase over what was projected, Madam President. And if we look at the budget further for 2024-2025, Madam President, you will note that there was a projection of an overall deficit of 0.26%, and I'm talking about the revised estimates, and at 0.26. Initially, when the budget was presented, it was 1.31. The revised estimates have it at 0.26. Now, if you do a calculation and you look at, and you do it based on direct proportion, Madam President, you'll come up that you'll note that these additional expenditures would bring the overall deficit to 1.39% of GDP. Now, I mention that simply because when you're looking at these overall deficits, these have to be financed somewhere. And again, it would be interesting to, and perhaps Senator Coy can take us over this in terms of how this gap would have been financed. Because you're looking at, you're putting on expenditures on, you're putting on additional expenditures in addition to what was presented in the revised estimate. So it would be interesting to see how this was financed. Madam President, I move on to the supplementary appropriations for 2025-2026. Again, and I'll use the same format that I just presented on. We had a total projected revenues of $1.7 billion and total expenditure $1.74 billion and a total expenditure of projected expenditure of $1.78 billion. So it's very close. Just a small gap there. You had a recurrent projected recurrent of $1.2 billion, a capital 2 of $336 million, and a capital 3 projected at $184 million. Now, what is being proposed here is $131 million, Madam President, and this represents a 7% increase over what was projected. The recurrent is $30 million, and that's a 2.4% increase over what was projected in a recurrent. There's $74 million in the supplementary for Cap 2, and that represents a 22% increase over what was projected. And then under Cap 3, there's a $27 million being proposed, Madam President, in a supplementary, and that represents a 14% increase. And like I said, total $131 million is what was mentioned before, and this represents a 7% increase, like what I had also mentioned. Madam President, the overall deficit that was presented at budget was $41 million, which represented a 0.6% of GDP. If we do the calculation and we look at the additional 131 million, I calculate that the overall deficit now is 2.5% of GDP. Again, just using simple direct proportion in terms of calculating it. And perhaps if I'm off on any of those numbers, perhaps Senator Courtney can correct me Senator Koyi can correct me when he makes his presentation, if he does. Again, Madam President, these all increase the expenditure part of it. We haven't seen the counterbalance on the revenue side on it. And so my question is how would this these expanded deficits, how would that have been covered? I mean, were they covered in terms of increased collections? Were they covered in terms of additional borrowing? I'd like some clarifications on that. And like I said, Madam President, my presentation, I wanted to go high level with it, and so I'm not getting into any of the line items and the detailed line items. I think that I think Senator Farber did quite a bit of that in his presentation. But overall, I think that when we look at budgets in March or April, Madam President, we spend a lot of time trying to strike this balance. And then when you look at these supplementary expenditures that, and in many cases we look at it after it has taken place, you wonder, you know, why all the effort in March or April to try to strike that balance when all of this is open up to all these millions of dollars that are being overspent. And so I'll close with that, Madam President. I'd like to get some clarity on the questions I raised, perhaps when the other speakers from the government side rise. Thank you, Madam President.
Thank you, Senator Kevin Herrera. Is there any other senator who will be making an intervention?
Madam President. Madam President, may I?
Yes, Senator Courtney, Leader Government Business, you may pose a question as we are nearing 12 noon.
Madam President, in accordance with Standing Order 10.8, I move that the proceedings on the order paper may be entered upon and proceeded with at this sitting at any hour, though opposed.
Honorable members, the question is that the proceedings on the order paper be entered upon and proceeded with at this day's sitting at any hour, opposed. All those in favor kindly say aye.
Aye.
Aye, remember, aye. All those against kindly say no. The ayes have it. Well, is there any other senator wishing to make an intervention on this particular bill or bills? Senate Leader Government Business, I believe you may proceed.
Madam President, I ask that the question be put.
Honorable members, the question is that the bill for an act to appropriate further sums of money for the use of the public service of Belize for the financial year ending on the 31st day of March 2025 be read a second time. All those in favor kindly say aye. Those against kindly say no. The ayes have it.
Bill for an act to appropriate further sums of money for the use of the public service of Belize for the financial year ending on the 31st day of March 2025.
Honorable members, the question is that the bill for an act to appropriate further sums of money for the use of the public service of Belize for the financial year ending on the 31st day of March 2026 be read a second time. All those in favor kindly say aye.
Aye.
Those against kindly say no. The ayes have it.
Bill for an act to appropriate further sums of money for the use of the public service of Belize for the financial year ending on the 31st day of March 2026. Committee of the Whole Senate on Bills.
Honorable members, in accordance with Standing Order 54, the Senate will now resolve itself into the Committee of the Whole Senate to consider the bills that were read a second time. At this time, I will be asking for the live streaming of the meeting to be suspended until the Senate resumes.
I'm coming back to your heart.
Foundations. Your work must be grounded upon solid rock, and so should your faith. Join Pastor Louis Wade Jr. weekly for Foundations Bible Study, where he goes deep into the Word of God with biblical teachings for better understanding.
A person might have potential inside of them, a desire to fulfill something, but the word of the Lord can bring that out of a person. Amen? So in the case of Gideon, though he felt that he could not do it, God had designated for him to do it. And so when God spoke the word through the angel, Gideon became who God knew he was all along.
Tune in on Plus TV Sundays for a new program or catch the repeats. We would love to hear from you. Write in and share your thoughts, prayer requests, or even pose questions you may have regarding the Bible passages. Foundations. Unless the Lord builds the house, those who build it labor in vain.
So when we face God, you know something. When I think of the love of the Lord.
Spice up your next event with professional lighting. Call 610-5679 and give your audience an experience they'll never forget. Proper stage lighting ensures stage visibility, motivates, and sets the mood of the atmosphere. We provide services for weddings, concerts, parties, dance recitals, and much more. Captivate your audience. Improve your production today. Call Shamax Productions at 610-5679 for quality and professional stage lighting.
Cyber Realty and Development is the leader in providing solutions to the current land crisis in Belize. For homeowners and investors alike, Cyber Realty is offering special deals on half-acre parcels in its new Emery Village development. Enjoy prime land off mile 37 on the George Price Highway at an unbeatable price. All you need is the initial down payment of $275 Belize dollars. Take advantage and reserve your half-acre home sites today. Emery Village. Join the community. Invest in your future.
Blessed Gardens is servicing home gardens across the country from the nation's capital and helping Belizeans reconnect with nature. We have everything you need for your home garden, so get growing. We have various types of soils: fortified soil, composted soil, potting soil, and pure compost for your garden. We have quality seeds and over 65 varieties of food seedlings for your garden. We even have organic insecticides available, EM soil treatment, and Polishade for your excessive sun or rain. Blessed Gardens has all your garden solution in one location. Call 610-5679. Visit us at the Bamapan Market Plaza or enjoy our free deliveries across the country. Blessed Gardens. Get growing, Belize.
Reporting on third reading of bills.
I recognize the leader of government business.
Madam President, I rise to report that the Committee of the Whole Senate has considered the General Revenue Supplementary Appropriation 2425, number 2, Bill 2025, and pass it without amendment. I now move that the bill be read a third time.
Honorable.
I rise to report that the Committee of the Whole Senate has considered the General Revenue Supplementary Appropriation 2025-26 Bill 2025 and pass it without amendment. I now move that the bill be read a third time.
Honorable members, the question is that the bill for an act to appropriate further sums of money for the use of the public service of Belize for the financial year ending on the 31st day of March 2025 be read a third time. Honorable members, the question is that the bill for an act to appropriate further sums of money for the use of the public service of Belize for the financial year ending on the 31st day of March 2026 be read a third time. All those in favor kindly say aye. Those against kindly say no. The ayes have it.
Bill for an act to appropriate further sums of money for the use of the public service of Belize for the financial year ending on the 31st day of March 2025. Bill for an act to appropriate further sums of money for the use of the public service of Belize. Bill for an act to appropriate further sums of money for the use of the public service of Belize for the financial year ending on the 31st day of March 2026.
So you have to mention adjournment, so.
No, I don't.
Yes.
I acknowledge.
Madam President, I move that the Senate do now adjourn.
Honorable members, at this point, Senator Kevin Herrera has asked for leave to move the adjournment of the Senate for the purpose of discussing a definite matter of urgent public importance, that matter being the economic and financial implications of unnecessary monopolies in business. Are there any objections to this request? If there are none.
Madam President, sorry, not an objection necessarily, but with your indulgence, please, just a few words on what you've said at the start of the meeting. Firstly, I appreciate very much your position that there will be some revision of the process, because indeed, I think that it is an injustice to have only one person speak. And I do feel for my colleague, Opposition Senator Honorable Gabriel, who indicated from the last meeting that he had this issue to present and in fact was told that he should bring it at the next meeting. So despite the fact that he submitted the request to do so and it fell in a lineup, I think we were all very much aware that he intended to bring this matter. It was something that you suggested that he do. And while he may not be pursuing it further, I assume, I just wanted to place on the record that I do believe that the current way it is being done is not giving justice to colleagues. And I'm happy to hear that you, Madam President, will be reviewing this process with the hope of making it better for members of this Honorable Senate. Thank you.
Thank
Madam
you,
President.
Senator Faber. Let
Madam
me also
President.
state that the Senate was on recess, and at the last meeting of the Senate, we did indicate to Senator Zetina that there was a process based on the section that he made the application on, which was 11.2, and therefore it was a requirement for us to send that request to the minister responsible so that that minister could then indicate which senator in the Senate would have replied on his behalf. Because we are on recess and this request came in from the leader of government business in accordance with standing orders for us to have a meeting within the recess period. That letter has not gone yet, so we were under the assumption that we will proceed with it, with that particular letter, once the recess was over. And so I do take your point, and I appreciate the fact that we are going through a process where we're seeing where more and more there are requests on the particular standing orders. And so we're hoping through the revision of the standing orders, as well as setting in place some technical guidance for future practice as it applies to the standing orders. So thank you. But I just wanted to share that it was not that it was forgotten. It was simply that the request had come in under 11.2. And so when his request come into under another section of the standing orders, it came in at a time, as I reported a little earlier, it was the third in line in terms of the lineup as to how they came. So I just wanted to share that it was not in any way ignoring his request to speak on the adjournment. It's just a matter of moving according to our processes. Leader Government Business, you wish to say something?
I crave your indulgence, Madam President, and just in your defense to clarify for the Honorable Senate that the interpretation of this standing order did not begin with you. It in fact preceded your assumption of office, and from my recollection, it was Senate President Lee Mark Chang who was advised that that is the way the standing order is to be interpreted. I'm not making a political point. I'm simply saying that it didn't begin with you. And I also, like Senator Faber, welcome the revision of the standing order so that we can make the as many people who wish to speak on the adjournment.
Thank you, Leader Government Business. I now pass the floor to Senator Kevin Herrera.
Thank you very much, Madam President. Madam President, I rise today to speak on a matter of grave national importance. A proposed move that threatens to dismantle 20 years of digital progress and competition in Belize. I start with a quote that I will also close with, Madam President. The people of Belize deserve better than a return to the past. I speak of the proposed acquisition of SpeedNet by Belize Telemedia Limited. We are being sold a narrative of efficiency, Madam President. We are being promised a strategic consolidation. But let us peel back the corporate jargon and call it what it truly is, the state-sponsored execution of competition in the telecommunication sector. History is a tough but effective teacher, Madam President, and the history of the Belizean telecom monopoly is a story of high prices and pain with telecommunication rates. So we don't forget the late 1990s, Madam President, when BTL enjoyed a profit margin of over 50 cents on every dollar in every revenue earned. And these records, BTL published its financial information from all the way back, Madam President. While on every dollar in revenues, they enjoyed a profit margin of over 50 cents, even while Belizean families were pleading for rate relief that never came. I remember that era vividly in the late 1990s, Madam President. was very early in my professional career at the time. We were representing Western Union actually, and I'll give you this story. We had installed a satellite dish intended solely for emergency digital transfers during national emergencies, Madam President. I remember BTL officials literally driving into our yard, ready to dismantle that equipment. Why? Because their license dictated that no one else could own technology with the potential to transmit voice. We know that's not what we were doing. They didn't ask permission, they didn't demand, they demanded submission. It took an intervention from a major provider in the United States who held equity in BTL at the time to force our own national provider to stand down. And this was because, Madam President, that Western Union was the largest customer of that provider in the US at the time. Madam President, that is the DNA of a monopoly. It does not innovate, it gatekeeps. It does not serve, it dominates. It was only the entry of SpeedNet that finally broke that chokehold, forcing prices down and data speeds up. To move back toward a single provider is a voluntarily walk back into the cage we fought decades to escape. Madam President, the BTL board argues that this merger is a survival tactic against the inevitable entry of Starlink. This is not just flawed logic, it is a dangerous delusion, Madam President. Buying competition is not innovation. Removing a local rival does not make BTL more agile against a global satellite giant. It simply makes BTL a larger, slower, and more bureaucratic target. How does saddling BTL with another $80 million in debt improve its ability to compete? If a customer wants low latency of Starlink, an $80 million buyout won't stop them from switching tomorrow. You do not beat a 21st century satellite network by buying up the sunset technology of your neighbor. Gambling with the people's money, Madam President, BTL is owned by the people of Belize through the Social Security Board and the government. We are being asked to gamble the retirement funds of Belizean workers on a 20th century business model. This isn't a strategic move, it's a high stakes bet using the public's purse and workers' money. Our BPOs, our students, our business community, Madam President, depend on affordable, redundant internet. Over 60% of our economy is service-based. By creating a super BTL, we are handing a single board of directors the power to dictate the costs of doing business in Belize. Competition is the only regulator that never sleeps. When you kill competition, you kill the drive to be better. We are creating a single point of failure. A super BTL falters, our entire economy will also falter. Madam President, we cannot allow efficiency to become a euphorism for control. We cannot allow a fear of global technology to drive us back into the arms of our domestic monopoly. I call upon the Senate, if we're ever called to deliberate on this matter, Madam President, that we look out for the Belizean consumers, that we look out for business, that we look out for the future of this economy. Like I said, over 60% of this economy is based on services. The platform on which services operate is a good a good, efficient, and effective telecommunications infrastructure. I call upon the regulators to remember that their primary duty is to the public, not to the balance sheets of a state-owned enterprise, Madam President. Let us not be the generation that sold our competitive future for a short-term illusion of stability. I stand firmly against this monopolization. Our people deserve a choice, our economy deserves a chance, and our future, like I started out, Madam President, deserves better than a return to the past. Thank you, Madam President.
Thank you, Senator Kevin Herrera. So as we come to the end of our virtual meeting,
Madam President? If I may, before the Leader of Government Business moves the adjournment, just congratulate you for your leadership in hosting this very first of its kind initiative to have the sitting virtually. I think you are truly revolutionary in this effort, and I note that again we have done so before the House of Representatives has done it, albeit it would have been far more difficult given their size to do it. I think it speaks volumes, Madam President, about your leadership and your vision for making this Senate more accountable and more efficient. I share with the Leader of Government Business, who often laments that the work is now very tremendous compared to what had been in the past. And so we are forced to try to find more efficient ways. I think this, since certainly I have come to the Senate, is the shortest of our meetings. And I am elated that I don't have to get into a vehicle now and drive home for an hour. I am at home. So I thank you and I salute you, Madam President, and of course the staff of the National Assembly that I am pretty sure worked to make sure that this became a reality. It's no easy task to do, especially the live streaming and get everybody on the same page and getting everybody looking so attractive and doing all the backdropping and everything else. I really think that it is an accomplishment for the history books, and I truly congratulate you and the staff, the clerk and the staff of the National Assembly. Thank you, Madam President.
thank you for your kind words, Senator Patrick Farber, but I would also want to say congratulate all of us for going through this first meeting. I do believe that there's quite a lot that we have learned, and certainly there's some areas that we will be reviewing and to ensure that as we progress, we improve. And of course, one cannot in any way not recommend and recognize the tremendous amount of work that has gone in by the staff of the National Assembly, and they do deserve a lot of kudos on that. I see Senator Rosella Rana would like to say something. Senator Rana, please do. You unmute.
Hi, good afternoon, everyone. I also would like to say thank you for your vision, Madam President, for this virtual call conference. As a matter of fact, I'm all the way in Barranco, and I don't have to travel 2 days to be at Senate meetings, you know. So this is indeed a step forward to betterment as we continue to work for the people of Belize. So congratulations, and Happy New Year to everyone. Happy New Year. Thank you.
Thank you, Senator Arana. And therefore, with that, I think I can pose the question. Senator.
Senator Courtney moves.
Leader of Government Business, I understand you wish to say something?
Not at all. I had moved the question already.
Oh, I missed that.
Honorable members, the question is that the Senate do now adjourn. All those in favor kindly say aye.
Aye.
Those against kindly say no. The ayes have it. The Senate now stands adjourned. Thank you all.
Thank you.